Geofabrics Limited and Fiberweb Geosynthetics.
Yes, Mr. Turner. I can tell you that we have read the judge's judgment, we've read the skeleton arguments, and we have read the patent in suit.
My lords, I'm grateful. My lords, I don't know if it's, obviously there's quite a lot of distance between me and my junior and my solicitor. If it's necessary to take instructions, I don't know if it's permissible to do it electronically through WhatsApp, or if you prefer, it may not be necessary.
Well, we'll see how we go.
Okay, my lord, I'm grateful. As my lords will then have seen, the issues which fall for determination are infringement and novelty, and the only claimant issue is claim 1, as recorded in the judgment at 48. And then my lords will obviously...
It all turns on normally, doesn't it? Normally in the absence of a train.
It does, yes. My lord, just in terms of definitions, my lords may have picked up the reference to subgrade that we see quite a bit is the soil. That's the soil there. And above that you have the ballast, and that's the sub-base. And then obviously above the sub-base you have the track sleepers and the rails, and you may not have a train, and that's sort of shown in the judge's judgment of paragraph 5, which my lords will have seen. My lords will also have seen from the there's an illustration of paragraph 7 of the judgment, which is taken from the patent, but it's without the invention. And you've there got the issue of the subgrade is shown as 122, and then the arrows, those wiggly arrows, are showing that liquid water can travel upwards from the subgrade, and there's a particular issue with clay, and it can carry with it fines in a sort of slurry, so very small bits of silt or clay material pass up into the ballast. And particularly when you get these pressure waves from the train, you see the train wheel 46 going across a rail, and then you see the load being transmitted through the ballast, labelled sort of 50. And this is the cause of pumping erosion, and my lords will have seen the sort of damage which can occur in paragraph 8 of the judgment, and then the problem of pumping erosion is elaborated by the learned judge at paragraph 9.
Yeah.
Before the priority date, pumping erosion was dealt with by sand. That's an incorporation, a layer of sand between the subgrade and the subbase, which slowed the passage of water and filtered out the clay and silt particles, and the judgment makes reference to that, paragraph 9. And there were also, it was known to use these liners, these geomembranes or geotextiles between the, actually they were typically within the sand, but they could be used instead of sand, and which helped to reduce, or was intended to reduce, this problem of pumping erosion. And obviously the patent is about an improvement, or said to be about an improvement to those types of liners. My lord, with that, I think I can go to construction. My lord, principles of construction was well known to the court. One needs to keep in mind construction is a question of law, of course. The patent has to be interpreted through the eyes of the person skilled in the art. That person is a legal construct. The role of expert evidence is relevant only insofar as it forms the court of the common general knowledge. And the meaning of any technical terms, any terms of art, any technical terms of art. Otherwise, construction is a matter for the court.
Yes.
The principles of construction we set out in our skeleton. I wasn't going to go to them unless my lord wanted to. They're paragraph 23. Those are the summary of the position from Virgin Atlantic. And with the caveat that when one comes to equivalence, the law has moved on in activists. Subject to that, those principles are still good law. Just to ask you to keep those in mind. So with having sort of cantered through my introduction, I hope that's all right, my lord. I was just going to go straight to the patent. And my lord is absolutely correct. We are concerned with construction of the phrase normally impermeable to liquid water. That's what this case is about. And you see there's an introduction in paragraph 1 of the patent, which I think my lords will have seen. And then in paragraph 2, there's a reference to the problem of pumping erosion. Sorry, my lord, if I'm going to... So, my lord, just going to the patent, there's an introductory paragraph 1, which my lords will have seen. There's then a reference to the problem in paragraph 2 of pumping erosion, which obviously the skilled addressee would have been familiar with. Then I really wanted to just pick it up at paragraph 7. There's a reference to a piece of prior art known as J, but referred to UK publication. And if we just pick it up in paragraph 7 at line 24, it says the geocomposite disclosed in 880 does not adequately address the problems of pumping erosion because the impermeable nature of the geomembrane is such that water cannot pass upwardly through it. Passage of a train along the support structure tends to squeeze groundwater in the subgrade laterally outwards. So that was the prior art. So it was an impermeable layer when you got the pressure wave from the vehicle. It couldn't go upwards because it was impermeable, so it went squirted out at the sides.
Carrying bits of clay with it.
Carrying bits of clay with it, precisely so. And then if one picks it up at paragraph 11, obviously this is a very important paragraph, so I'm going to take this slowly if I may. It says reference is made herein to the at least one filtration layer being of a material which is normally impermeable to liquid water, which should be taken to mean that the material is impermeable to liquid water in the absence of the load of a vehicle acting on the track bed.
So this is a case where the specification is its own dictionary.
Exactly.
Not only that, a little unusually, the claim is its own dictionary, because this definition is carried through expressly into the very words of the claim.
My lord, precisely so, yes.
So why is that not an end of the question of construction? We have a definition which is not merely set out in the specification, but carried into the claim.
Yes, my lord, I think that is our submission, that is the definition that's carried into the claim. I think one then needs to, my learned friend would certainly say, one then needs to go on and ask, what does that mean, having given a definition?
After that, it's a question of fact, isn't it?
I think...
Does the material which is alleged to infringe have that property, or does it not?
Does it not? Yes. And I think the issue between the parties is whether that's talking about permeability in both directions. We say from water coming up from the bottom of the subgrade into the ballast, or is it concerned only with permeability of rain to rainwater coming from the top? That's the sort of issue between the parties, and
that's not at all the issue I've understood from your skeleton argument, which seems to be an attempt to write a numerical criterion into the claim which is not present.
My lord, will come to. I don't think there's an issue on the numerical once one determines the question of the direction, but perhaps we need to read on just to clarify that.
How would water penetrate upwards in the absence of any pressure exerted on the...
So there's a load exerted on the subgrade, the ground. There's a load, and that load is coming from the ballast and coming from the rails and coming from the sleepers, and that's a considerable load. It's about 2.9 kilonewtons. That creates a pressure which will force water up through the membrane into the ballast. My lord, I'm going to come back to my Lord's point about numerical values, but that comes later. So so the definition, we say, is clear. Normal in that definition means absent a vehicle. So it's
That's
normally
common ground.
impermeable. It means impermeable to liquid water in the absence of a load of a vehicle on the track bed. So that's the meaning of normality we submit. Then if we go through, accordingly, will be understood that the pressure applied to the track bed liner by the vehicle is sufficient to cause the filtration layer to permit passage of liquid water upwardly therethrough. So we're being told that in distinction to the state of affairs when there is no train, when a train passes, the pressure is sufficient for the water to pass through the liner. And in contrast to the prior art, during these movements, where the pressure wave with the train hits the material and it goes out the sides. So the pressure applied to the track bed line by the vehicle is sufficient to cause a filtration layer to permit passage of the liquid water. Then it goes on, however, the pores of the filtration layer will be dimensioned so as to restrict the passage of solid materials even under the pressure of the vehicles. Mind all that's clear. And then continues, it will therefore be understood that the load of the ballast, sleepers and track located on the liner will generally not be sufficient to cause the liquid to pass through the filtration layer. In other words, the pressure exerted upon the track bed liner by the ballast, sleepers and track is not sufficiently high to cause the liquid water to pass through the filtration layer. So the patent is having regard to the pressure exerted by the load of the track, ballast and rails, but that isn't sufficient to allow the water to pass upward from the subgrade into the ballast. In technical terms, the experts, as part of the common general knowledge, that means it does not exceed the water entry pressure. So there's a pressure at which water will pass through the textile, and that's called the water entry pressure. We'll come on and have a look at that a little bit more in a minute. So there's a distinction between the pressure applied by the rails and the ballast on the one hand, and the pressure applied by the train on the other, the vehicle on the other, and the water entry pressure has to lie between the two. Then if we continue on, it says this offers the advantage that once the vehicle has passed, any water which has passed upwardly through the filtration layer cannot return back down through the filtration layer. The water instead falls naturally along an upper surface and is forced out of the track bed by the subsequent applications of pressure from successive wheels of vehicles. And furthermore, this offers the advantage that the volume of liquid water due to natural rainfall passing down to the subgrade is restricted, as it cannot pass down through the filtration layer. So once the water has passed up, it does not pass back down. And then at paragraph 12, I think we can pass over, then paragraph 13 says the at least one filtration layer may be normally vapor permeable. And then if we drop down to line 46, the at least one filtration layer may be of a polymeric material, and then various materials are suggested, and my lords will have picked up, which becomes relevant when we get to Novelty as a reference to Gore-Tex at line 57. My lord, we should then come to paragraph 20. And again, we see this phrase repeated, the at least one filtration layer may be normally impermeable to liquid water, but may become permeable on application of a sufficiently high pressure to the surface of the filtration layer. And then various figures are given, which are repeated in different parts in the spec. So it suggests the filtration layer may become permeable on the application of a pressure of at least 5 kilonewtons, 10 kilonewtons, and then one can read through up to 100 kilonewtons. And then it says at line 15, permeability may depend upon factors including the material forming the filtration layer composite, dimensions of the filtration layer composite, including the pore diameters and or thickness. And if we then pass on just two more passages. So 49, we again see these figures repeated in 49. Ask my lords read that.
What do you say the relevance of these figures are, given that in every case it says maybe?
Yes. Yes.
And that nowhere any statement that it must be.
Yes. So it will depend. I was going to come on and address that in a moment, my lord, but just sort of jumping ahead. Of course, it will depend on the circumstances. And tracks can be of different weights. For practical purposes, the evidence is for practical purposes, it will be around 2.9 kilonewtons as a matter of fact. But I'm going to come
on to that in due course, but I think it follows that you're accepting that the figures that are set out in 49, for example, are irrelevant.
It depends. I think one would have to just address relevant to what, I think.
Well, they're not a criterion in the claim.
They're not a criterion in the claim, that is correct.
Right.
But we come on to other passages which look at this in a little bit more detail. So if we then pick it up at 54, it says, as mentioned above, the filtration layer, 30, may be normally impermeable to liquid water. However, in use and under the load of a vehicle on the trackbed, in the case of a train, the filtration permits the passage of liquid water upwardly therethrough. So it's onto the train, you then get this passage of liquid water upwardly, therefore, and we would say not before, but restricts the passage of solid materials, so as to restrict pumping erosion. So in contrast to J, where it all squirted around the side, now when a vehicle goes over, under that force, the textile becomes permeable and the water passes through, but without the clay fines. Then just dropping down to 21, furthermore, the liner 24 permits passage of water from the clay subgrade into the ballast, which occurs during passage of the train along the track 14, providing a dewatering effect. Water flows from the subgrade because the pressure exerted upon the liner and thus upon the filtration layer as the train passes over each sleeper track sufficiently high force liquid water upwardly through the pores of the filtration layer and into the ballast 20. However, following the passage of the train, when the pressure acting on the filtration layer reduces and then is due only to the load exerted by the trackbed and the track, the filtration layer once again becomes impermeable to water. So again, emphasizing that the pressure of the load exerted by the trackbed and the track is not sufficient to meet the water entry pressure of the textile. That only happens when you have the higher pressure created by the train. And then some figures are put onto that in paragraph 56. However, the inventors believe that the water will primarily or entirely be transmitted through the filtration layer in liquid form. The water transmission occurring due to increased pressures exerted on the filtration layer when the train 34 passes along the track 14, as will now be described. So line 13, typical static loading on the filtration layer would be less than 10 kilonewtons and maybe approximately 2.9 kilonewtons. So this is the patent saying what a typical track pressure would be and in this static situation, and that there's no dispute about that 2.9 kilonewtons. The evidence from my learned friend's expert was maybe a little bit of variation, could be 2.5 through to 3 kilonewtons. And that gives a ballpark figure. The peak vertical dynamic stress during the passage of a train would typically be around 10 and maybe between 10 and 100. So my lord's quite right, these definitions are not written into the claim, but they're not inconsistent with the position of the parties. You can get trains certainly above 60 kilonewtons. We'll have a look at that evidence in due course. And 2.9 is about the right figure for the track without the presence of the vehicle. Perhaps I should just look at it. It's in tab 4 of the tab 4 of the supplementary bundle is the expert report of Dr. Sangster, my learned friend's expert. And I think we can take it from paragraph 11, I think it is. So it's a sort of, the load on the subgrade is the combined weight of the track, sleepers and ballast. Second sentence. This static load, dead load, so the fourth line, fifth line down, is typically in the order of 2.5 to 3 kilopascals. And kilopascals are the same as kilonewtons, my lord.
Yes, and as he explains, that's got nothing to do with water pressure.
Well, we'll come on to that, my lord. I think it depends whether...
Static load of the track, sleepers and ballast. Newton's third law, equal and opposite reaction from the subgrade. So the material is in compression, in equilibrium, but what we're concerned about here is the water pressure, which, as he has explained, is something different.
Yes, so it depends whether you're talking about from the top or from the bottom. I think the experts were of the view that when the water was above the membrane, above the textile, it wouldn't be seeing the pressure of the ballast and the rails, because it would sit between the interstices in the ballast. But the patent, and we've looked at the passage, and I don't think there was any dispute about this, was that, at least not by the time we got to, at least not in the judgment, put it that way, was that when the pressure, the water under the membrane in the subgrade does experience the pressure. It experiences the pressure when there's a vehicle, and it experiences the pressure from the rails and the track, which is why there's these repeated references to this load. The specification is making repeated references to the load of the rails and the ballast, and rightly so. So the one needs to distinguish between the one and the other. And then while we're here, sorry, I put my finger in it, I took my finger out. Okay, my lord, I'll have to come back to that. I just missed that reference. So you have water sitting under the, and of course this has got pores sitting in the pores or under the pores in the subgrade, and the static pressure is considered by the patent to be relevant in forcing that water upwards. So always on the one hand distinguishes between the pressure, the static pressure of the rail and the ballast, and the dynamic pressure of the vehicle. And if the static pressure wasn't relevant, the patent wouldn't be repeatedly referring to it. So that's clearly the criteria which the patent applies. So can I turn to claim 1 with that introduction? So a trackbed liner, which Lords would have seen, is the claim, and we say it's a trackbed liner which is normally impermeable to liquid water. That means under the pressure of the ballast and the rail, but in the absence of a vehicle. And one cannot, it's assessed when it's a trackbed liner. So you have to ask the question, does it infringe when it is laid? It's not a question of it infringing when it's in the warehouse. Does it infringe when it's laid? In those circumstances, absent a vehicle, will it be impermeable to liquid water?
I'm sorry, I don't understand that. This is a product claim,
Yes.
not a method claim.
Yes.
So you surely must be able to decide whether or not it infringes when it's in the warehouse.
Because, well, it has to be a trackbed liner, so it has to be...
Yeah, but that's just simply telling you what it's used for. It is a liner usable for a trackbed.
Yes. So if one posited...
You're not seriously saying this is limited to the liner in situ, are you?
Right. So if one posited a very, very light railway track, so a very, perhaps in the model, with a little model railway next to me, in the garden centre next to me, which is very, 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 very light, and one can imagine putting down a liner on that, and in those circumstances, absent the vehicle, absent the train going over, because it only creates a very, very low pressure, perhaps that particular trackbed liner on my hypothesis is not impermeable to liquid water in those circumstances. So it's a trackbed liner, but it's not impermeable to liquid water. But if I take that same liner and put it in a conventional railway where there's a heavier load on the ballast and the rails, then it would become permeable. So that's all I'm suggesting to my lord. I don't think anything turns on it in this case, is that it may depend on the circumstances when it's laid. So in a typical case, here, where the trackbed liner is laid, the load is going to be 2.9 kilonewtons, and the question is it permeable at that point? If it was, I don't think anything turns upon this, and it may be a sort of, whether trackbed liner carries with it, whether it's just any bit of Gore-Tex, say, or whether it carries with it the, does it have to be labelled for use on a railway, or does it have to actually be on the railway before it's a trackbed liner? That's just
so
my submission.
can I have a yes or no answer to my question? Is it your submission that this claim is limited to the in situ use?
Yes, my submission is, I don't think anything turns on, but my submission is that a trackbed liner is when it is laid on the track, because until then it's not a trackbed liner, it's just a bit of...
So if you could use the same material for a different purpose, then whatever the claim means, it doesn't infringe.
Yes, so if it was used as a raincoat, it wouldn't infringe. So it's a piece of Gore-Tex. In the end, it's a piece of Gore-Tex with some... and if it's used on a railway line, it infringes. And if it's used to make a coat,
it doesn't. Your submission, the moment before it hits the trackbed, it is not infringing, and the moment it hits the trackbed, it is infringing.
Yes, that's not to mean
How
to mean
on earth
one.
do you get that out of the claim?
Well, just all through trackbed liner. So it's a bit like, my lord, I'm sort of regretting having raised this. I don't think anything turns on it ultimately. But this claim does not catch all Gore-Tex in the world. It only catches that Gore-Tex which is used as a trackbed liner.
On conventional principles of interpretation, one would have thought this means a liner which is suitable for trackbeds. And of course, it has to comply with all the other requirements in the claim.
Yes.
And therefore, it's certainly not the case that any piece of Gore-Tex will do, because that doesn't comply with the other requirements in the claim.
Yes.
But what's wrong with interpreting trackbed liner as meaning liner suitable for use on a trackbed?
Well, my lord, that is the alternative interpretation. I don't think anything's going to turn on it, certainly not on infringement. So my lord has had my submissions. I was then going to go on and say, well, if we look at the next clause, in the pores of the filtration are dimensions so that, in use under the load of a vehicle acting on the trackbed, the filtration layer permits the passage of liquid water.
I'm sorry, where are you? I thought you were in claim 1.
I am, my lord. Sorry, I've just gone on to the next integer. We just looked at, which is normally impermeable to liquid water.
Oh, yes, yes.
And the next integer, which the pores of the filtration are dimensions so that. Now, just pausing there, unlike some of the subsidiary claims, it's not requiring pores of a certain dimension. It's defining the dimension of the pores functionally. So, obviously, smaller pores have a different water entry pressure to larger pores. If the pores are very large, it's permeable to water all the time. If the pores are very, very small, it's like, as they are typically in Gore-Tex, then it will only, water will only enter under a certain water entry pressure. So in which the pores of the filtration layer are dimensioned so that in use, under the load of a vehicle acting on the trackbed, the filtration layer permits passage of the liquid water upwardly. So then one, again, forensically, it's helpful to ask, is it only infringing when the train passes? My lord, we don't...
There's no dispute on 1.6, integer 1.6. I'm using the numbering in the judgment at paragraph 48. No dispute that that integer was satisfied by Hydrotex.
That's correct, my lord. That's correct. Yeah. But we say that it has to have the capacity to do that. So it has the capacity when a train comes along too. So it doesn't just become infringing when the train passes. It's infringing all the time. If it's such that it has the capacity to become permeable when the train passes. So, my lord, I think that's the construction my lord was sort of urging on me for the first clause. Certainly we accept that for the second clause. And then, my lord, will see we're not concerned with subsidiary claims, but it's just of note. Got claims like claim 3, where the size of the pores is 2 microns. So there they've been defined functionally and by size. And then if we look at claim 11, we've got a particular pressure threshold, 10 kilonewtons in claim 11.
Yeah.
Before turning to the, let me just, so in order to decide whether a trackbed liner will fall within the scope of the claim, you have to ask, does it have properties, in other words, pore sizes, such that they become permeable under the load of the train? And is it impermeable absent the load of the train, under the load of the ballast and the rails and the track and the track sleepers?
And you answer the first of those questions yes, and the second one no.
Yes, that's correct. And because we say for practical purposes, there's no expectation. The relevant figure that I can test is the 2.9 kilonewtons. And to tell whether your trackbed liner infringes, you don't do experiments on the track, as was done for this case. You determine it experimentally in a lab. You can ask the question, what are the relevant pressures? The pressure of the track is going to be 2.9 kilonewtons, or 3 kilonewtons if you prefer, and you can test it in a lab. Say, is it permeable under that load? And then you can do the same.
And what you're testing is the water pressure. The experiment you would do is the water pressure test. Yes.
Yes. It's done as it's done where you'd apply a pressure to water of 2.9 kilonewtons. So this is in circumstances, of course, we're concerned with when the ground is wet. So you have this clay sodden with water, and as the pattern makes clear, it's the pressure of the rail and the ballast that results in that pressure being exerted on the membrane, on the textile.
I'm being slow, I haven't quite understood that. I thought the whole point of this was that it was impermeable when it rains. So how does the clay get sodden when it rains?
So the clay, the whole problem is the clay tends to be wet. So the clay is often wet. That can come from underground water, that comes from atmospheric conditions. And when you have the rail, we'll look again at bits in the passage. So if passages in the patent, So if you go to claim 11, for example, as a paragraph 11, for example, looking back at this, pick it up at line 54, it will therefore be understood that the load of ballast, sleeper and track located on the liner will generally not be sufficient to cause liquid water to pass through the filtration layer. In other words, the pressure exerted upon the trackbed liner by the ballast, sleepers and track is not sufficiently high to cause liquid water to pass through the filtration layer. This is in the inventions. So that pressure exerted by those elements is not sufficient to cause the water to pass through the filtration layer. The assumption is, of course, the water is there. This is an invention for precisely to deal with the problems of wet ground where there's a slurry and it's coming up and causing this pumping erosion. And similarly, Lord, if we go back to say paragraph 53 again.
53?
Yes. Line 30. However, following the passage of the train 34, does my lord have that? Sorry. However, following the passage of the train 34, when the pressure acting on the filtration layer reduces and is then due only to the load exerted by the trackbed and the track, the filtration layer once again becomes impermeable to liquid water. So you have this slurry, particular problem in London, because it's all clay, it's very wet and it's prone to forming this slurry. And you want, when the train passes, you have this release of pressure, water comes through, but absent that, the pressure reduces and is only due to the load exerted by the trackbed and the track. And at that point, once again, it becomes impermeable to water.
Yeah, the water doesn't go down again.
The water doesn't go down, but it doesn't go up either. So it's the load exerted by the trackbed and the track. That load is experienced by the water under the filtration layer. So the filtration layer once again becomes impermeable to liquid water. Now my learned friend says this load by the trackbed and the track is irrelevant. Cross it out. Don't have to take account of it. But that repeatedly through the specification, the patent is telling you that that is an important load.
He doesn't say it's irrelevant. He says it's a constant and that Newton's third law applies to it.
Yeah, well, I think he says it's, well, I don't anticipate what he says. But there is this constant pressure of 2.9, and if the pores are small enough, that will not result in water seeping up through the liner. Before turning to the judgment, I just wanted to remind you of the infringement, the alleged infringement. That's in the tab 18.
This is your PPD.
Yes, that's PPD. And just going to the end, my lord, they just see this is the Hydrotex. We can take this fairly quickly. There's a filter layer in the middle, which is what we're concerned about, because that's what limits, that's what creates the water entry pressure. That's A. You can just see it's drawn as a very thin line. And then around it, there are two other layers. There's a layer B.
I apologise, I'm in the wrong place. Could you give me the reference again?
Yes, I'm sorry, my lord. It's tab 18. Supplementary bundle, tab 18.
Thank you.
Hey, I'm just right at the end of that tab, my lord. Those are just starting with the drawing. So this is the Hydrotex. So it has a filter layer in the middle. That's A, and then it has two other layers, which are one's a spun bonded layer. That's B, so it's a laminate, and then C is a needle punch sort of upper and lower support layer. And there's adhesive is the D, and B is the flame lamination, but essentially 3 layers. And we're only concerned with really the layer in the middle, the sandwich, that's A. And if I can go to the judgment. And the learned judge starts considering the patent at 38, and at 40, the learned judge picks up the definition that we looked at the start of paragraph 11. He just cites the start of paragraph 11, at least one filtration layer being of a material which is normally impermeable to liquid water, which should be taken to mean that the material is impermeable to liquid water in the absence of the load of the vehicle on the track bed. And then I just wanted to pick it up at 60.
60?
Yeah. My lord may not have looked at this section,
yeah.
But we were running an insufficiency argument. Professor Ingold is our expert. And he said, look, this won't work. This pattern won't work. And you'll hit the same problem as J, with material being squirted out the side. So his theory, simply put, product made in accordance with the patent will never work. Slurry will pass through the filtration layer so as to be filtered. Instead, his evidence was that slurry will move laterally under the load of the train, travelling through the lower support layer towards the edges of the geomembrane, where it will be disgorged into the drains. The path of least resistance for the slurry under the load of the train is never through the filter. He said it's always laterally. If Professor Ingold is correct, then the product made to the patent functions relevantly identical to the invention set out in J. My lord saw that in paragraph 7. And then the judge comes back to this at 63. Says, in addition to the empirical evidence, Mr. Sangster also gave his views on why Professor Ingold's theory was not correct. And he deals with that. And then at 64, we see the judge conclude, in my judgment, Professor Ingold's theory is inconsistent with the empirical evidence set out above and is open to the criticism Mr. Sangster made of it, just at the end of the paragraph, but his theory is inconsistent with other empirical evidence before the court, was criticised by Mr. Sangster, and I reject it. So we failed to succeed on that point. The
judge's reason on construction is all in paragraph 73, isn't it?
Yes, I'm going to come to that, but this I think is relevant background, particularly when we come to my learned friend submission, so I just wanted to pick that up. And then my lord is absolutely right. We come to 73. And it says, considering the patent through the eyes of the skilled addressee, he takes a little bit slowly, and applying a purpose of construction, in my judgment, normally impermeable to liquid water, that is in the absence of the load of the vehicle, that means what it says. In normal conditions, the filtration layer will not allow water to pass through it. At 11, the patent sets out the reason for this, so that rainwater and water that passed up through the filter will run off the sides. And the skilled addressee will appreciate that the product is to be used on a railway track. Those normal conditions, therefore, when in use as a geotextile under the ballast and above subgrade as part of the railway track, the normal conditions include the weight of the ballast, sleepers, and rails, but not a train. They also include the presence of rainwater, including any water that has been permitted to pass upwards through the filtration layer, but not a flood. Now, just pausing there, we say so far the judge is correct to be considering the weight of the ballast, sleepers and rails at this point. And the judge has also gone further and added in a quantity of standing water, which may exert a pressure. The patent doesn't anywhere say this is a relevant load to be considered. But we then need to...
Well, is it your submission that rainwater is irrelevant?
I think it's we're not quite sure that it plays a specific role.
Well,
so the water,
certainly in this country, as we've experienced over the last month, rain is a constant hazard.
Yes.
And one might have thought that was something the skilled person would know and would take into account.
Yes. So what the patent is concerned about is the passage of water from the slurry underneath the railway, underneath the membrane, from the slurry up into the ballast, because it's this that causes pumping erosion. Now that water level, that slurry, will of course be impacted by all sorts of things, environmental things.
Well,
Rain over a
including the
period.
rain.
It could include rain. But when it's below the membrane, it's not clear to me that that rain would be exerting a pressure when it's below the membrane. So the slurry that the patent is concerned about is seeing a pressure from the liner and from the ballast and from the tracks and from the train. Those are the pressures it sees. Now there will, if there is standing water above the liner, then of course there will be some pressure by reason of that water above the liner as a matter of physics.
Exactly. And as a matter of everyday experience, we know that rainwater gives rise to a degree of standing water. It's called a puddle.
Yes, yes. So, so when one's considering the issue, that the problem that the patent is principally concerned with is this passage of water from the subgrade into the ballast. The relevance of the rain is only how directly or indirectly the water gets into the subgrade in the first place.
Well, exactly. But
Do
that's
you
the
quarrel
point.
with the judge's use of the phrase "in normal conditions"?
At which bit?
Paragraph 73, line 3, for instance, line 8, is it? And then 9.
Yes, we do.
You do.
Yes, we do. But he sort of gets, not so much the first time, because the first time he says normal conditions. So this is sort of line 7. He says, those normal conditions are therefore, when in use as a geotextile, under the ballast and above the scope grade, those normal conditions include the weight of the ballast sleepers and the rails, but not a train. We don't disagree with that.
You say that's right.
We say that's right.
But equally, as I understand it, you don't criticise the proposition that one's not concerned with flow condition.
No, we don't criticise that.
So he's right about that as well.
Yes. But can I read on and then just sort of, we need to look at the whole paragraph, I think. So the experts both accepted under normal conditions water would not pool on top of the geotextile in substantial quantities because of the way in which railways are constructed. So my lord, going back to puddles, my lord has seen, stood by the railway station on a rainy day, you notice they're sort of built up so the water sort of drains off. And that's what's being said there. I say something further below about what describes as bathtubs of water resting on the filtration air. The patent does not refer to stands of water, but the experts agreed a stand of water of greater than 50 millilitres would not be normal because stands of water would not arise in usual, i.e. not normal flow conditions. I do not consider that the skilled addressee would assess permeability from above in the light of the pressure applied by the track and the ballast. So this is where one needs a little bit of care. So we do not dispute that insofar as one's talking about water lying above the membrane, you would not be concerned with, that may well lie in interstices and may not see the weight of the ballast and the rails. But you are concerned, as the judge has rightly said, held previously, just over the page, with the weight of ballast sleepers and rails, because that is exerting a pressure on the water, the slurry, which is under the membrane, and it's that the patent is concerned with. So the judge is wrong here to say the skilled addressee would assess permeability from above in the light of the pressure applied by the track and ballast. But certainly that is a relevant pressure applied to the slurry below. And as the patentee sets out, the load of the track and ballast, but not a train, would approximately be 2.9 kilonewtons. And there's no issue around that figure. This is a pressure applied on the top of the geotextile by the weight of the ballast sleepers and track. It is not the pressure applied from above by the water, which experts will agreed will be between the graded crush rock will run off to the sides. That's the That's the point I've been making. And just reminding my lords of paragraph 1154, you've got it well in mind, I'm sure. Clearly, the pressure exerted by the track bed and the liner is relevant, and it is relevant because one is concerned with the pressure being exerted on the slurry below.
So is your overarching point that the judge was wrong to concentrate or to discuss almost exclusively water passing through the geotextile from above, and what he ought to have been doing was to consider water rising from below?
Absolutely. Absolutely. And that's what we say one gets out of these passages. And what one can get it you know, from various places, and we just looked at paragraph 53, where following the passage of the train, the pressure acting on the sort of paragraph 53, line 30, following the passage of the train, when the pressure acting on the filtration layer reduces, the filtration layer once again becomes impermeable to liquid water. And at that point, it has in the brackets, and the pressure is due then only to the load exerted by the track bed and the track. So you have a slurry under the
static load imposed when you lay it, and thereafter the system's in equilibrium.
No. Well, it may be in equilibrium in some respects, but there is a pressure. There's a pressure.
There's a static load. It's the system's in compression. Newton's third law. I still haven't understood what the answer to Newton's third law is.
Yes. But my lord, that sort of comes, lots of criticisms were made of this patent. My lord, might be a further criticism of the patent, that the theories underneath it are incorrect. What?
You don't have to have a valid theory to have a valid patent. Your theory as an inventor may be completely wrong, but your patent may still be valid.
Yes.
And we're not concerned with validity at this
point.
But we will be when we come to Hall.
Sure. But my submission is the patent says you have to have regard to the 2.9 kilonewtons or whatever other figure load attributable to the ballast and the rail. And that's how you assess whether you're inside the claim or outside the claim, because that's what the patent is telling you. The patent says repeatedly, at every juncture, it distinguishes on the one hand the load of the vehicle, and on the other hand, the load of the, my lord puts it, the static forces. So when you come to ask, do you have a membrane falling within the claim, and if my lord's suggestion to me you don't even have to have laid it at that point, then you just simply ask that question, is it permeable at 2.9 kilonewtons, or is it not? And if it's permeable at 2.9 kilonewtons, it falls outside the claim. And of course, my lord is right, you can cross out that 2.9, you can put in a different figure if you feel it's appropriate to do so, depending on particular circumstances. That's how do you determine whether you're inside or outside claim. Otherwise, the patent would be not having regard to the load of the sleepers and the ballast and the rail. That's what repeatedly tells you have to have regard to. So, my lord, there may be certain equilibria set up. That may well be the case, but the fact is those pressures, the patent is telling you those loads are relevant. And the criticism, when we made criticisms of the of some of the teaching in the patent, the learned judge found against us on that, and which is why our insufficiency claim failed.
Yeah.
So, at no point does the specification say it is only concerned about loads from above. It's common ground that you don't get that the load, and from above I mean above the trackbed liner. It's common ground that above the trackbed liner, any freestanding fluid will not see the load of the ballast and the rails. And the reference at paragraph 15, lines 13 and 30, liquid water passing upwardly there through, shows that is what the patent is concerned about, principally concerned about water passing upwardly there through. And the fact that one also gets an effect that water from above runs off is of course of interest, but it doesn't define the limits of the claim. And the patent, rightly or wrongly, and my lord is putting to me propositions of physics, the patent does consider the load of the ballast and the rail to be relevant. And the judge is not having sufficient regard when he construes the patent. He's not having sufficient regard to the teaching of the patent. He doesn't pick up the definition, doesn't at least carry through the definition of normal that's given in paragraph 11. He replaces it and says that normality is something to do with the amount of rainfall. And in so doing, he's not saying those figures are common general knowledge or those figures are referred to in the patent implicitly or explicitly. And by getting drawn into this definition of normality and assessing it by reference to the amount of water lying above the trackbed liner, the learned judge is reading a teaching into the specification and into the claim, which isn't there. So we say it's perfectly straightforward to construe this claim. Normally impermeable to liquid water means impermeable at a load which is equivalent to the track and the ballast, and that we say, for practical purposes, we can take that as a figure of 2.9 when it comes to assessing infringement. So if I can then go to infringement, my lord, paragraph 24 of the judgment.
I think if you're right on construction, then there's no infringement.
That's
because your material was permeable at a pressure of less.
Somewhere between 0.5 and 2.7.
Sorry, give me those figures again, Mr.
Yes, so if you go to, it's in the judgment of paragraph 24.
Yeah.
Hydrotex has a water entry pressure somewhere between 0.5 and 2.7. So they only did two tests. They tested at 0.5 and they tested at 2.7. And it lies, we don't know whether it's closer to 0.5 or closer to 2.7, but somewhere.
At any rate, it's below what you say is the magic number of 2.9.
Below what you say, yeah. My lord, the judgment then goes on to consider what the judge describes as equivalence. I'm not sure it is equivalence in my submission, but if we could have a look at it. It's at 159.
Sorry, 159.
149, sorry, my lord.
Yes. I'm not sure that Mr. Hicks was relying on equivalence.
Yes, it's a sort of hypothesis as to different environmental conditions. And I don't think either party is really relying on that. So, my lord, I'm quite happy to deal with that in reply if I need to.
Well, let's see if Mr. Hicks wants to make an argument about it.
So, can I then turn to novelty?
Yeah.
And we go to was going to go to a passage in...
Well, just so as we're not under any doubt, can I just articulate why I think it's being said that we don't need to worry about equivalence? The key is what you just said. It's the phrase you used, environmental conditions. And the reason why we don't worry about it is because you're not relying upon environmental conditions as part of your non-infringement argument. As you accepted earlier, we're not concerned with floods.
I think that's right.
Yeah, and once that's accepted, then the whole argument about equivalence goes out the window.
Yeah, and so we don't need to dissect that. Whether it's
Understood. Thank you.
So just really, just to speed things up, I was just going to take my lords to a passage in Terrell, or a couple of passages in Terrell. That's at tab 7 of the authorities bundle.
Is this the extract we got originally, or the...
Yeah, this is the extract you got originally, my lord. The other one was just, I don't think we need to...
Right, so it starts at... My clip starts at paragraph 1170.
Yes, but I think we can pick it up at 1176. And there's a well-known citation from General Tyre.
Was there anything wrong with the judge's summary at 77 and 8?
Nothing save that it's incomplete, my lord. Incomplete in a material way. So there's a passage from General Tyre, and then if we look at the commentary at 1177, asks where the directions are capable and carried out in a variety of ways, some of which fall within the claim and others do not, and there is no clear and unambiguous direction, but at best a signpost. And that's, it says this is the qualitative difference being stressed in Tyre between the inevitability test in the claimed way and at least as likely in some way. So if you can perform the invention or the prior art in different ways, some of which fall within the claim, some of which do not, you lose. There's then a citation from Synthon. Synthon was a case where the prior art had misdescribed what it produced. So it was a question of whether it was described in the right terms. And just in the middle of that citation from Synthon, says, but the patent infringement does not require that one should be aware that one is infringing. Whether or not the person is working the invention is an objective fact, independent of what he knows or thinks about what he is doing. And then there's a reference to Merrill Dow. And then we see in the text, down to 1116, the need for clear and unmistakable directions, therefore, does not require equivalence of language, merely of teaching. And this is illustrated by the House of Lords in the decision of Merrill Dow. So sometimes saying a rose smells as sweet by any other name. So it's a question of what it is, not how it's described. My lord, I just wanted to look, and so you have to, if you're relying on an inevitable result case, you've got prior directions in a piece of prior art. It's not describing the invention in identical terms. You have to say, is it the inevitable result of carrying out that teaching that you will make something falling within the scope of the claim? And inevitable result, just wanted briefly to mention the decision of Mr. Justice Burse in Tarvis, where it actually is picking up a reference in an earlier case. That's at tab 4. If one goes to 406, the learned judge here is grappling the difference between inevitability, that it's inevitable you would do something, and what is the standard of proof. It's still inevitability on balanced probabilities, if that makes sense. And the learned judge quotes Mr. Justice Floyd, as he then was, in paragraph 407. Could I just invite you to read the quotation? over the page, Ms. Justice Bursey respectfully agrees with the learned judge. And then finally, my lord, I wanted to go to tab 3, which is Dr. Reddy's, and I think we can pick it up at page 236, paragraph 23. And in this case, the prior art disclosed, or the question was, did it disclose a drug called olanzapine? And we can see it. 23, it says olanzapine is one of 10 to the 19 compounds of a Formula 1, that was a generic Marcouche formula, and one of 86,000 compounds of the preferred class. And Lord Justice Jacob then considers at 26. First, the a priori consideration, apart from the case law, no question to answer runs as follows. Where does a wise man hide a leaf in a forest? Makes that point. And at 29, similarly makes no sense to say that a generalized prior description discloses a specific matter falling within it. The judge's example illustrates the point. A prior disclosure of fixing means is not a disclosure of a particular fixing means. And then finally, just going over the page, after the citation in paragraph 30, it says, so what one must look for by way of anticipation is an individualized description of the later claimed compound or class of compounds. This is miles away from that. It is not necessary, dropping down the next paragraph, not necessary here to go into what is sufficient to amount to an individualized description. Obviously, the question may be partly one of degree, but other considerations may come in too. So, it's a matter of fact and degree, of course, but if you have 80,000 chemicals listed out, and the key chemical is in that list, that may well not be an individualized description. If you have 10 compounds listed out, they're probably an individualized description of each of the 10. It's a matter of fact and degree and circumstances. But the key thing is you're looking for an individualized description. It doesn't have to be the only individualized description. It has to be an individualized description. I just wanted to, got in my note to remind you of other aspects of the common general knowledge which were not in dispute. I think we may have picked up most of these. There are two types of geosynthetics used in railway construction. There are geomembranes, which I think I've referred to. These are not permeable. That was like the J example. They're essentially bits of plastic film. Neither fines nor water can pass through them. They're just a barrier. And these were the ones where you can get squirting out the side. And the other type, which have been around for a long time, are geotextiles.
Sorry, can I ask you, what's the relevance of this? Because we're concerned here with novelty.
Yes.
And there's no issue on enablement. Therefore, we don't get into common general knowledge at all, do we?
Yes, so it's
a question of the disclosure of Hall.
I think, my lord, that's right. It's just so that my lords have in mind the concept of water entry pressure, which will become relevant. So, and this will be relevant when we read Hall and Gore. So obviously, if they're not impermeable and they have holes in, there will be a water entry pressure depending on the size of the holes. And water entry pressure is a concept which is part of the common general knowledge. And that's recorded in the agreed statement of common general knowledge, which is at tab 13. I probably don't need to show you that one, also.
Set out in the judgment. Paragraph 53.
Yeah, indeed. So our case, essentially, we say the patent in suit describes a geotextile. I'm paraphrasing here. It describes and claims a geotextile which is water impermeable under the load of the train and the ballast, and has a water entry pressure below that created by the train. So the water entry pressure is below that created by the train. And if you recall, the patent, we had a look, paragraph 13 makes reference to the relevant track line as being vapor permeable, and it also made reference to Gore-Tex. And we say that the prior art publication of Hall which as you recall cross-refers to gore, contains an individualized disclosure of a trackbed liner or material for a trackbed liner, which in use will be impermeable under the weight of a track, but permeable when a train passes. That's our case. And we say that it is not described in the same terms as the claims in the patent in suit. Does not matter. And just going to come to those disclosures in a minute, but just sort of jumping ahead and looking at the judgment. Paragraph 88A. The judge says the claimant points out the invention described in Hoare, even including the reference to gore, does not read onto the structures described in the patent. Hoare does not describe the use of a filter layer, nor does it reference a layer which is normally impermeable to water, but allows the upward passage of water under the load of a train. Hoare does not address these concepts at all. And we say, well, that's, I'm going to come back to deal with 88B, but certainly as regards 88A, that's not a relevant factor. The question is, at least not a determining factor. The question is there a instruction in Hoare to make something that falls within the scope of the...
For the purpose of the novelty argument,
Yes.
does it matter which construction of the patent is correct, or does the novelty argument depend on your construction?
No, the novelty argument doesn't depend on
So whether the judge could be right on construction, and if he is, then you say the novelty argument runs just as well.
Yeah. So if we can go to Hoare, which is at tab 2. I don't know if my lords have looked at this or in any detail. It relates to, just taking the first page, it talks about pavements, improvements to pavements, but you'll see right at the outset it includes railway pavements. And just to paragraph 2, it picks up that there's a sub-base and a subgrade. One sees that being described. I was picking it up at line 16. When it's not clean, i.e. when it contains a large quantity of fines, undrained conditions develop, which ultimately lead to the failure to perform acceptably. It is therefore necessary to protect the sub-base ballast during its lifetime from contamination by soil fines. Contamination by soil fines occurs as a result of pumping of fines from the underlying subgrade into the sub-base, and the sinking of sub-base particles into the subgrade usually occurs when the following combination of conditions arise. It says the subgrade is cohesive, so this is like clay, very sort of solid. The pavement above the subgrade lacks fine particles. Free water exists at the subgrade sub-base interface. So you can get this free water in between. And my lord was talking about pressures. Of course, you know, a static pressure can nevertheless be a very real thing, as anyone who goes diving will know. The pressure of and the pressure above you when you're diving has all sorts of impacts, and particularly when you've got the potential to release that pressure through pores. So then it says the pavement is subject to cyclic dynamic loading, and then it refers to railway pavements. It says, in order to prevent the pumping of fines, it is known to employ a layer of sand separator between the subgrade and the subbase. Line 15, it says, attempts have also been made to prevent the pump of fines into the subbase by the use of a textile sheet material to act as a separator. And then it deals with some of the problems with that, such as textile materials efficiently in preventing the coarse aggregates, but they don't, of the subbase layer from penetrating cohesively. However, their action in the reverse direction, namely to stop the migration of fines from penetrating the coarse aggregates, is doubtful. And then paragraph 5, it's therefore an object of the present invention to mitigate the problem of pumping of fines. And then at 6, it's one of aspects of the present invention resides in the use of a multi-layer structure. And then it sets out, and it's the lower, we don't have to worry too much about the rest, it's the lower flexible sheet that we're concerned with. We see that at line 15, the lower flexible sheet material being, and there are 3 options, substantially water impermeable, but provided with perforations or slits therethrough, or B, water vapor permeable, but substantially impermeable to liquid, or C, substantially impermeable to liquid water and water vapor. And if we have a look just at the figures at the back, so looking at figure 2, that's on towards the back of the patent, and that's a sort of sideways slice through. You've got these 12, Mark 12, these are the load-bearing discs, load spreading discs, which are made of resin, and you can see there on figure 1 that you've got a plan view, you can see them there. And then the lower layer, 16 here, this is the one that is has perforations. 14 is water permeable anyway, so we don't have to worry about that. But it's the lower layer, 16, which in this particular embodiment, which is embodiment A, has these perforations, which allows the water to pass through. And then at figure 3 on the next page, and figure 4, we see, let's take figure 3 first, we see this is another embodiment, this is embodiment C, where it's completely impermeable, so this is like J. Nothing can pass through, even under the weight of a train. And you can see in figure 4 that it's the gist of what's going on is you've got the subgrade, which is 22, you've then got the trackbed liner, which is 20, and then you've got the ballast, 24 above it, and then you've got some other structures, because this is a highway rather than a railway in this particular illustration. So going back to the text, we should have a look at 17. Says in the case where the water flexible, so it's described these 3 embodiments, and we rely on the central embodiment, material B. In the case where the lower flexible sheet material is type B, material, i.e. water vapor permeable, but substantially impermeable to liquid water, such material might be a composite sheet formed of a pair of outward water permeable textile layers with an intervening water vapor permeable barrier, e.g. a barrier layer formed of an unsintered sheet of polytetrafluoroethylene, which is expanded so as to produce a fine microstructure characterized by nodes and interconnected fibrils. See example GB13, etc. 373. So that's, as the learned judge accepted, incorporated by reference and is part of the disclosure. It's the pulling apart of this polytetrafluoroethylene which leads to the spaces which permits water to pass through. And so we then need to go to Gore. And remember, from Hall, we're looking for a material which is substantially impermeable to liquid water, but permeable to water vapor. And this is the substance that's known to any teenager who's done his Duke of Edinburgh Awards, Gore-Tex, which of course allows water vapor to pass through, but when it's used on the mountains, doesn't allow water to go in the other direction. So just pick up a couple of passages. If you look at column 1, line 35, it says, according to the present invention, there is provided a porous polymeric material containing units derived from tetrafluoroethylene and materials having a microstructure characterized by nodes interconnected by fibrils, the material having a matrix tensile strength. And that's, of course, what's been described in Hall, these nodes and interconnected fibrils. And then picking up at line 65, says porous materials in accordance with the invention generally have a good combination of porosity and strength. In this regard, they are generally better than previously available fluorocarbon polymers. The porous materials are permeable and they can be laminated, impregnated and bonded to provide composite structures. We can then, I just think, pick it up very briefly at page 3, right-hand column, line 105. The materials generally have permeabilities to gases and in some cases to liquids, which are much higher than those of conventionally moulded or extruded polytetrafluoroethylene. And then I think last passage before the example we need to go to.
Pardon, Mr. Turner, I've missed that reference. Where was that?
Sorry, my lord, it was page 3.
Oh, page 3, sorry, I misheard.
Right-hand column, line 105.
Yes, thank you.
And then page 4, left-hand column at the sort of start, says as a result of the ability of materials in accordance with the invention to transmit fluids, they can also be used as filter membranes to separate.
Where are you, Mr.
Sorry, page 4,
Yeah.
left-hand column at the top, third line. Should first
British patent specification.
Sorry, I'm in Gore. Are you in Gore, my lord?
In Gore, so am I think. So it's tab 1.
Yes. Page 4 internal. Is that what I'm...
Oh,
Sorry,
I
my
was
lord.
looking at the bundle page. Right.
Sorry, I do beg your pardon.
So as a result of the ability of materials.
Yes, yes.
Yes, got it.
As a result of the ability of materials in accordance with the invention to transmit fluids, they can be used as filter membranes to separate solid materials from gases and from liquids. For optimum filtration rates, relatively low permeability, small pore size membranes are preferably used to filter out small solid particles. With high permeability, large pore size being used to filter out large solid particles. Also, expanded amorphous lock materials in accordance with the invention can be used as semi-permeable membranes for separating wetting fluids from non-wetting fluids. Wetting is a technical concept of sort of something spreading across a surface. And then it goes on to explain, for example, a gas-saturated membrane in contact with water and a gas will transmit the gas, the wetting phase, as described above. It will not transmit the water, the non-wetting phase, as long as the pressure in the water phase does not exceed the water entry pressure for that particular combination of membrane and fluids. So it's water impermeable and vapor permeable, as being described in Hall. And the skilled person, of course, is familiar with the concept of water entry pressure. We then have various examples. And the example that we rely on is example 10, which we say is an individualized disclosure. And we see it's entitled an expanded amorphous locked film as a filter membrane or as a semi-permeable membrane. Then it's an extruded, calendared, unsintered Teflon 6A polytetrafluoride film. The film was expanded and amorphically locked using a machine. It tells you how to make it. And then it refers to its properties below in the table 9. And then over the page it says it can filter out smoke. That's in the first paragraph on page 12. And then picking it up at line 9, samples of the expanded amorphous locked film were also used to filter solids from suspension of solids and various organic liquids. Again, good separations obtained, filtration rates were reasonably high. And dropping down to the next paragraph, when an effort was made to flow water through the expanded amorphous locked film and containing air using 5 psi flow pressure, no flow occurred. However, when the flow pressure exceeded 10 psi, flow started. Thereafter, the flow of water through the membrane was quite similar to that of organic liquids which wet the membrane. This membrane was found to be useful in separating solids from dispersion of solids in water.
So it's permeable at 10 psi.
10 psi and not permeable at 5 psi. And doing a conversion, which we need to do, is 5 psi is 34.5 kilonewtons per meter squared, and 10 psi is 69 kilonewtons. So the load on my construction, a fortiori my learned his friend's construction, if the load experienced by the filtration layer arising from the weight of the track and ballast is 2.9, it will be impermeable at that, if that's the relevant figure, because it's impermeable up to 34.5. And at the other end, Patten describes loads of a train up to 100 kilonewtons. The expert report of Professor Sangster, tab 4, page 14. Perhaps we should look at that. However, in applications where loads in excess of 69 kilonewtons, does my lord have that? So sorry, perhaps I've jumped in a bit. Taken from the fourth line. Therefore, if such pressures would not be reached in use, example 10 could prove to be a suitable barrier layer material. However, in applications where the loads in excess of 69 kilonewtons were expected, for example, railways specifically carrying ore from mines to ports, the example 10 material will be considered, I mean, he's saying it's unsuitable, but what I rely on it for is that, look, you know, you can get loads of in excess of 69 kilonewtons, up to 69 kilonewtons, particularly when you're moving minerals and so forth, so freight trains and so forth.
So why does the reader of Hoare select example 10 of Gore?
Yes, so we say the reader of Hoare. So can I just show you two bits of cross-examination, but it's the only suitable example, the only example in keeping with the teaching in Hoare. And the cross-examination on that, which I'd like to go to, is at tab 11. I wanted to pick it up at a couple of short passages.
This is Mr. Sangster, is it?
This is Mr. Sangster being cross-examined by Mr. Pritchard. And just three short passages. So first of all, 200, page 200, line 12. If I'm reading Hoare as a skilled person and I'm looking for its description at option B, I'm sorry, it starts at paragraph 17, does it not? It does, yes. And it refers to the intervening water vapour permeable layer. And you see the unsintered sheet of PTFE, you see that, I do, yes. Then it talks about expanded PTFE, which is expanded to produce fine microstructure of nodes and interconnected with, yes. You see that, and that is a geotextile. It is non-woven, if you like, one might say. The description of a geotextile, or the definition of the ISO, starts with the term used in contact in soil, and it goes on. So the context of geotextile is in use, but it has those properties. Some of those characteristics will be similar to geotextile. As we discussed a moment ago, it has a water entry pressure, yes. And then we go on to example, so that's Gore-Tex having a water entry pressure. Then we go on to example 10, or Hoare, sorry, describing a water entry.
I'm baffled. I thought this is all about Hoare.
Yes, sorry, I misspoke, yes, about Hoare, the concept of a water entry pressure. And then at 202, we then go on to Gore, I beg your pardon. So we pick up Gore at line 23, 201, line 23, and go to 202, line 9. We turn example 10 on page 11. We have something that describes an expanded amorphously locked film. Yes, we see that. And then you see the description, you have commented on it. So unless you want me to go through it line by line, I will not. What we're taught is that it's impermeable at that figure. Yes, and it's permeable above 10, yes. So it is acting like a conventional geotextile with a water entry pressure. It is water entry pressure between those two limits, and we are told that it is useful in separating solids from dispersion. Yes, we are. And then I wanted to go to
So where in that passage does he put it to the witness that the reader of Hoare would inevitably go to example 10?
Well, we'll look at 208, line 10, line 11, Mr. Pritchard. If I take all the examples in Gore, example 10 is in fact the only one that is impermeable under any conditions. It is not. So all the other examples were just permeable. I believe so, yes. All the other ones are permeable, yes. So there's no dispute that example 10 is the only example which is consistent with the teaching in Hall and which you would therefore be drawn to as a matter of course. Now, of course, so just bringing this together, what our submission is, we say that in Hall there's a disclosure of a trackbed liner in accordance with the claim. Layer B is a material which necessarily has a water entry pressure. Hall does not state whether the water entry pressure is above or below the pressure exerted by a train, but points you to Gore. You then go to Gore, it means there's an individualized disclosure of example 10. And whatever else there is an individualized disclosure of example 10. It doesn't have to be the only one. But example 10 is in fact the only one which is both water impermeable and water vapor permeable and is a filter. It's the only one that satisfies the criterion. Now, the fact that the skilled person coming to Gore from Hall might also seek to work outside example 10, if that was the case, does not mean that there's not an individualized disclosure of example 10. Example 10 is an individualized disclosure. So then if we can pick it up in the judgment, it starts at 79, and we were looking, I think, we pick it up at 84. It says, Gore, I accept for the purpose of this case the defendant's submission that the express reference to Gore means that Gore is to be taken as part of the disclosure of 4. So 84 must be correct. Then at 85, he deals with example 10, sets out its properties, also separately tools being used for filtration. And then he comes to the judgment at 88. We've had a look at 88A, but just again, the claimant points out the invention described, including reference to Gore, does not read onto the structure type. Gore does not describe the use of a filter layer, nor does it reference a layer which is normally impermeable to water, but allows the upward passage of water under the load of the train. But my lords had my submission on that. On B, then, Hall directs the skilled addressee to a choice of 3 lower layers. That's correct. Those are the A, B, and C, of which the defendant relies on type B. That's correct. This is a 3-layer sandwich construction, but Hall directs that the middle layer must be substantially impermeable to liquid water. Professor Ingold gave no clear answer as to why the skilled addressee would ignore this requirement, even taking into account example 10 from Gore. And the judge here is ignoring that all materials which are vapor permeable will always have a water entry pressure. They have holes in them, there is always a water entry pressure. And the reference to the material being impermeable does not mean it does not have a water entry pressure, nor does it teach away.
Don't quite understand that. The point the judge is making, as I understand it, is that Hall tells you that what you need is something that is, quote, substantially impermeable, unquote.
Yes.
Even if the reader of Gore focuses upon example 10, what they find there is something that it is permeable, at any rate at 10 psi.
Yes, all materials, and this is why they all have a water entry pressure. So I showed you that cross-examination. All materials will become of this type, i.e. materials with pores in them, which is what we're talking about. They will become water permeable at a water entry pressure. And the only question then is, at what water entry pressure? Now, for most of the examples in Gore, they were just permeable. Example 10 is the exception, which is impermeable.
No, it's not impermeable. It's described as being impermeable at 5, but permeable at 10.
Yeah, so impermeable atmospheric, impermeable at 5, and has a water entry pressure, which is implicit in all these materials. And that was the cross-examination I showed you, that these materials will always have a water entry pressure. So what Hoare doesn't say is that it's impermeable, that it's not. He refers you to Gore-Tex and the Gore patent, and he does not say and the nature of the material, these fibrils that are pulled apart, means it will always have a water entry pressure. So what Hoare is teaching is you go to Gore to find something that's impermeable. That does not mean it doesn't have a water entry pressure. That would make no sense. And that's what was put to the witness.
But if you went to Gore looking for something that was substantially impermeable, you'd come up with all the other examples.
No, they're
not 10.
No, they're impermeable. They are permeable. They are water permeable at atmospheric. You don't have to apply any pressure. They're like a piece of cotton or something. They've just got big holes and the water pours through. So example 10 is the only one which is water impermeable. Save when you apply
the nearest to a water impermeable might be a more accurate one.
Well, all the Gore materials will be water permeable under pressure. They all have to be permeable under pressure because they've got holes in them.
So the alternative view is that what Hoare is referring to Gore for is not actually any of the examples, but the methodology of how you make a relevant material.
Well, but they will all, that doesn't meet the point about permeability because they are all necessarily impermeable. If you recall the description in Hoare, necessarily permeable under pressure. They're pulled apart, they're nodes and fibrils that are pulled apart. So they will always...
So just pausing there, is your submission therefore as follows, that even though Hoare tells you that the material you want is something impermeable, nevertheless, the type of material disclosed in Gore, to which is cross-referred to, is inherently permeable
under pressure. Has a water entry pressure, it must. And if you go back to Hoare, paragraph 17. It has a microstructure characterized by nodes and interconnected fibrils. That's precisely what's being described in Gore. So if you go back to Gore, Gore is about taking this polytetrafluoroethylene. You saw that at the beginning, the passage we looked at the beginning, and then you stretch it. And you stretch it so that its microstructure becomes characterized by nodes and interconnected fibrils. And that's a quote straight from the page 1 of Gore, which we looked at. So therefore, it inherently has pores, and the only question is the size of those pores. Which is why when we went to the cross-examination, Mr. Pritchard put that it will have a water entry pressure. That was in the context of Hoare. Perhaps just go back to that. 200 line, tab 11. So that's 200.
201, is it?
200. So starting at 200, yes, it goes on to 201. Sorry, so I'm reading Hoare, and he's reading paragraph 17. It refers to the intervening water permeable layer, and then it talks about an expanded polytetrafluoroethylene, which is expanded so as to produce a fine microstructure. Yes, so you see that is a geotextile, and then the witness takes the point it's not a geotextile until it's in the ground. But then he says, as we discussed a moment ago, it has a water entry pressure, yes.
But there's no reference anywhere in that passage of cross-examination to the requirement in Hoare for a substantially impermeable layer.
Well, he's putting option B in paragraph 17 at line 200, line 13. So that's what is being talked about. And it will have a water entry pressure.
If the case was that the reader of Hoare would read substantially impermeable knowing that in fact the material would be permeable? That would surely have to be put.
Well, I think the context is understood that all geotextiles have a water entry pressure. So once you put holes in something, it inevitably has the capacity to water to flow through, and it's just a question of what pressure it will flow through. And I don't think there's been any dispute about that at any stage. And what the cross-examiner is putting to the witness here is precisely that point. It has a water entry pressure, yes. And then the question is, what is that water entry pressure? So if you go to the
All right,
agreed common general
I follow
knowledge-
the point, but let's pursue that a little further. So the skilled reader of Hoare understands that there will come a pressure at which the water enters.
Yeah.
But suppose it's 1,000. Why would that be relevant?
Suppose it's 1,000 kilograms.
Yeah.
May not be.
So it then has a water entry pressure.
Yeah.
And so why does the skilled reader not think to himself, well, it says substantially impermeable, but I know these things, there will always come a point where if you apply enough pressure, it will permeate. Why did he not think to himself, well, that could be 1,000?
So I think, if I can very impertinently paraphrase my Lord's question, what my Lord is putting to me, you may have geotextiles with a water entry pressure which remain impermeable under the weight of a train, under the load of a train. And the 1,000 being my Lord's example. But there's no evidence to suggest that that is in any way being contemplated. The point's put against me.
Of course it's not contemplated. That's part of the judge's point. But what I'm trying to tease out is your submission as to what the skilled reader of Hoare, who knows nothing about the patent, understands. And I understand the point you're making, and it may be that this is not contested, that the skilled reader of Hoare knows that there must come some pressure at which the material is permeable.
Yes, that's it.
But Hoare doesn't tell you any particular pressure. The only guidance Hoare gives you is the phrase substantially impermeable. And it might be said, also it's all part of your argument to some extent, well, substantially in itself concedes that it's not completely impermeable. So again, there will come a pressure.
Yes.
But the question then is, well, what's the inevitable result, given that you are not given any criterion as to what the pressure you want is?
Yes. So the inevitable result is there is an individualized disclosure of example 10, and there's a teaching to go to Gore, and all the other examples are automatically dismissed because they're not impermeable at all.
So the reasoning works something like this. I read Hoare. Hoare tells me to make a type B product.
Which is water vapor permeable.
It also tells me to go and look at Gore. When I look at Gore, I can discard almost everything in Gore because it doesn't fit with what Hoare teaches. But there must be something in Gore that does fit. So it's got to be example 10.
Yeah, and example 10 fits because it's vapor permeable and it's filter.
And therefore, when I read the phrase substantially impermeable to liquid water in Hoare, I must interpret that as encompassing the degree of water permeability in example 10 in Gore.
Yes, I think one needs to be careful with the substantially. I'm not placing weight on that because all three, so you've got three membranes.
Yeah, quite.
You've got A, which is completely permeable.
Yes, well, as
You've
my
got
Lord
B,
said.
which is water permeable,
Yeah.
and you've got C, which is impermeable. It's a plastic layer. And C is also substantially impermeable. So I think the substantially is just the patent. No, substantially vertical. You put these words in just so you don't get...
Have a bit of wiggle room.
You get a bit of wriggle room, yes. So I'm not relying on the substantially. What I am relying on is the vapor permeability. As soon as the skilled person sees vapor permeability, they understand it has holes in. It's different to example C, which is a barrier material. And once it's got holes in, it'll have a water entry pressure, so it'll be permeable under pressure. the skilled person then goes to gore, and there is only one example, and that's an individualised disclosure. And the skilled person, of course, may decide to do other things, may decide to make things from scratch, but that doesn't take away from the fact that there's an individualised disclosure of example 10.
Right. So, on this basis, the obviousness argument should have succeeded, but it didn't.
Well, it didn't succeed. It didn't succeed. I mean, we say the judge is wrong, obviously. That's why we're here.
Yes, but you refused permission to appeal on that.
We refused permission to appeal on the obviousness, yes. And so if I could just go back, we were just in the judgment at 88B. So Professor Inger gave no answer to why the skilled person would ignore this requirement, even taking into account example 2. Even so, the skilled actually considering Hall wanted a water permeable layer, Hall would direct him. And what we say the judge is doing here is slipping into obviousness. And one needs to be a little bit cautious. Of course, my lord can ask, well, would the skilled person reject something? But one needs to be a little bit careful to start imbuing the skilled person with choices. So we say there's an individualized disclosure, example 10, which is consistent with the teaching in Gore in light of the common general knowledge. One needs to be careful. The judge here seems to be slipping into, he says he prefers something else, you know, or would direct him to type A material with large perforations. So we say in this paragraph the judge is slipping into obviousness.
Would it not be a slightly odd conclusion to reach that something is anticipated but not obvious?
It happens quite a lot.
Does it? Right.
Well, I don't know, it happens, and it can happen in circumstances where you hadn't realised. So let us hypothesise.
I see. If you didn't
realise that it was so useful to have this valve, then there can be considerable overlap. But there are novelty cases where you didn't realise the inventive concept, but nevertheless you made something that satisfies the inventive concept. That can certainly happen. My lord, I didn't have anything to add at this moment. Hold on. Okay, Mr. Pritchard's just asked me to remind you of tab 13 in the
core or
supplemental.
Supplemental.
Yeah, this is what the judge quotes at paragraph 53.
Yeah.
So E, F, G, and H. Concepts of water and pressure were when any other further
Anything more?
No.
questions?
Thank you very much, Mr. Turner. Yes, Mr. Hicks.
Well, so I'll deal with that in the same order as my learned friend. So,
Could you take your mask off? It makes it easier to hear.
yes, easier to speak as well. Yes, I was going to deal with matters in the same order as my learned friend, so I'll deal with the normally impermeable point first. And for obvious reasons, it's important to distinguish between, on the one hand, the question of claim interpretation, and on the other, the facts relevant to infringement, which concerns the characteristics of the Hydrotex product. And we say that in my learned friend's submissions, from time to time, he confuses those 2 points, and that on the question of claim interpretation, he's trying to add an impermissible gloss into the plain words of the claim. Now, this morning you've heard a bit about how railway tracks are built, but if I may just spend a little bit more time on the subject to dispel a couple of points which may not be clear in your lordship's mind. The first is the nature of ballast. The ballast is an open structure of crushed rock, and the rock is about 50 millimetres or 2 inches inside. So the purpose of the ballast is manifold, but one of its purposes is that water can run freely down through the ballast. until it hits something. Now, if one doesn't have a trackbed liner,
And the ballast isn't absorbent, is it?
no, it's just an
granite.
open. It's the stuff one sees on railway lines on the top. It's the large, large gravel or small stones one sees, and that runs down for a depth, and water can just run freely through that, and it acts as a foundation for the sleepers and the track, but it also acts as a drain for water to go through. And if one doesn't have a trackbed liner and one just puts the ballast on the so-called subgrade, in many instances there's no problem, because rainwater comes from above, it hits the soil, and because the soil is porous, it drains away naturally. Some may run away to the side, and others may drain naturally downwards. The problem of pumping occurs where the soil's got quite a high clay content, and quite a significant proportion of UK railway lines are built on that soil. And the problem with clay, a high clay content soil, is twofold. First of all, it consists of a lot of fine particles, and secondly, the clay is practically impervious to water. Clay line things hold water. And that's what gives rise to the problem of pumping. Because if the clay gets wet, the constant motion of the trains on the track pushing the ballast up and down causes the wet clay to turn into a liquid mud, a slurry. And then as trains pass overhead, it's akin to a child stamping in a puddle. The slurry-bearing water splashes up into the ballast, dries and sticks to the ballast, and eventually the ballast becomes contaminated. So what the patent's concerned about is two things. First of all, in an ideal world, what one would like when one's laying a railway track is to have something which stops rain from above getting into the clay subgrade. That would be one useful thing to have. And one could do that with an impermeable liner. Rain would just fall from above. What one would also like to do, and this is what the patent solves, is to have a way of drying out, or dewatering as the patent calls it, wet clay underneath. And the process which the patent describes for that is that the dewatering effect occurs as a train passes overhead. It creates a rapid cyclical load on the trackbed liner, and each time a wheel goes overhead, a little bit of water is ejected upwards from the damp clay, upwards through the trackbed liner, where it comes to a stop, the train moves away, and the water drains off on either side. So the patent's got this twofold advantage. It's not just concerned about getting water out from below, it's concerned also with rainwater coming from above. Now, the experts agreed, and the judge found as a fact, that the weight of the ballast and the track and the sleepers was not something which acted on the water so as, in a sense, either to push water down from above, or
You're talking about the water in the clay.
well, I know. There's two places the water can be. So, what the experts agreed and the judge found as a fact that was, so far as rainwater was concerned, the only thing that would affect whether the rainwater passed from above and through the trackbed liner was the depth of rainwater.
Yeah.
The ballast had nothing to do with that. Similarly, when there's no train there, because the system is in equilibrium, there is nothing which forces the water from below upwards through the trackbed liner, because the system is in an equilibrium state. And the only thing that causes water to pass from the clay below the liner upwards is the passage of a train. So so far as water passing downwards is concerned, I think my learned friend's accepting that the weight of the ballast and the sleepers and the track has nothing to do with it.
Indeed, he focused his submissions this morning on the water going up.
Yes. So far as water going up, that's also the case. It has nothing to do with the weight of the ballast track. It's got everything to do with the trains passing overhead. And perhaps if I can just show you a passage, and this wasn't in dispute, but if I can perhaps show you a passage from the cross-examination of Professor Ingold, where he deals with this point. It's a passage I mentioned in my skeleton, and it's at tab 12, page 220 of the bundle, page 265 of the internal pagination of the transcript.
Sorry, just Hicks, give me the reference.
Supplemental bundle tab 12, internal page in the top right, 220, bundle page 220 in the top right, page 265 of the transcript. And if I could pick, we're discussing various matters here, but if I could pick it up at line 12, where Professor Ingold says, for example, the Hydrotex, and indeed the liner of Patten, the only time that water will be expelled from the subgrade is during the transit of a train, because it's the pressure of the train that actually pressurizes the pore water in the underlying clay in the subgrade, causes that to try to jet upwards. So the only time water will be ejected from the subgrade is during the passage of the train, which applies the pressure. And then perhaps you could just read from the bottom of his answer on page 265, just to the end of his answer, 266. So, as a matter of fact, Hydrotex is indeed impermeable to liquid water in the absence of the load of a train, in the sense that in the absence of the load of a train, rainwater falling from above will not pass through it, and any water which hasn't been dried out in the clay subgrade will not pass upwards from below. So the only question we submit to your Lordship then is whether the claim has, say, some special meaning or gloss attached to it. We say not. And perhaps if I can take you through some of the passages in the patent to show you why we say that is the case. Could we begin? Well, my learned friend referred you to paragraph 7 of the patent. And that was a reference to one of the pieces of prior art that were discussed at the trial called J1. And J1 involved an impermeable geomembrane. And that solves the rainwater problem, obviously, but it doesn't solve the problem of how one might dewater the clay underneath. And the problem is that if one puts the liner on a damp, wet clay, as the patent explains, the slurry forms and it just shoots out to the side. Now, so picking it up at paragraph 11, and before I get to that, I just want to make one point clear. The patent shows, and I'll show you the passages where it does, that one can't ignore the weight of the ballast and the track, for the simple reason that one needs to design the liner in a way that will withstand the weight of the ballast and the track, will withstand the sharp stones of the ballast, and will withstand any stones in the subgrade. So one has to take it into account, but it's not relevant to the question of whether water will pass. So picking it up then at 11, the first sentence explains, as Lord Justice Arnold says, provides its own definition, which is repeated in the claim. Normally impermeable to liquid water means impermeable in the absence of the load of a train of a vehicle acting on the trackbed. The second and third sentences of paragraph 11 then explain what happens when a vehicle passes over the track. Water can be forced upwards through the liner, but the pores of the filter layer are chosen to be sufficiently small to avoid undesirable solids passing through. In other words, clay. So as the train passes overhead, water pushes up through the trackbed liner, leaving behind the undesirable clay particles. That's why it's called the filter layer, because it's filtering out the particles of clay. The fourth sentence is one relied upon by my learned friend, starting at line 54. It will therefore be understood that the load of ballast, sleepers and track located on the liner will generally not be sufficient to cause liquid water to pass through the filtration layer. In other words, the pressure exerted on the trackbed liner is not sufficiently high to cause liquid water to pass through the filtration layer. And the experts agreed that that would indeed be the case. It is in fact not relevant to the question of whether water will pass through, and that's a statement of fact. It just doesn't happen. The next sentence, starting in column 3 on the next page at line 2, explains in the next 3 sentences the advantages of the patent. So the first one is this offers the advantage that once the vehicle has passed, and thus the load exerted by the liner upon the liner by the vehicle has been removed, any water which passed upwardly through the filtration layer cannot return back through the layer. So that's one advantage. And in the next sentence, it explains where the water goes. It flows laterally or longitudinally and away into drains, which are normally specially constructed on railway lines. And then in the final sentence, it deals with the other advantage. Finally, this offers the advantage that the volume of liquid water due to natural rainfall passing down into the subgrade is restricted, as it cannot pass down through the filter layer.
So it's using the passage of the train to extract water from the subgrade.
Yes.
Bit like a cat's eye in that way.
Yes. That's what the patent's about. It's the passage of the train.
So it's rather than the passage of the train being a disadvantage, you're actually capitalising on it.
Indeed. And this sort of discussion obviously played a significant part in the case when we were considering obviousness, and that large quantities of the track had been laid and so on. But we're not dealing with that now. So what we say is that when read in context in a purposive manner, it's clear what the purpose of the normally impermeable integer is. It's to stop rainwater falling from above, passing down through the liner, and to stop water which has been forced from below by the passage of the train falling back into the subgrade again. And with that purpose in mind, there's no reason to read into the claims a requirement to resist more than this amount of water for the invention to produce its desired effect. Now, as I mentioned, that the product's got to be constructed so that all this happens, the material's sufficiently strong to work. And if one looks at paragraph 19, one can see here a discussion about what the upper and lower support layers consist of. So, as a minimum, one has a 3-layer product, an inner filter layer, and then one has upper and lower support layers. And then in the next sentence, it gives an example of a suitable support layer, a needle-punched polypropylene geotextile available from Geofabrics registered trademark. So that's a fairly open fabric type material. Then at line 42, it then says the upper and lower support layers may have a thickness in the range of 5 to 20 millimeters. And then it goes on to say it will be understood that the thickness will vary according to factors including an expected loading on the liner in use and the required depth and nature of the ballast. Optionally, the upper support layer may be thicker than the lower support layer to account for the fact that the upper support layer may be in contact with the ballast, whereas the lower support layer may be in contact with less aggressive materials. And it goes on to say that they may be materials which have a relatively high water permeability, so that water will run laterally through them. So that's why we say patents tell you you mustn't ignore the weight of the sleepers and the ballast and the track, but you mustn't ignore it because you need to protect the filter layer. Paragraph 20 is a paragraph which my learned friends referred to in their skeleton, but that is simply providing some details of the operation and some typical facts and figures of the liner when the train or the vehicle is running overhead. Now, if I could move on to paragraph 41, and there's a section in paragraph 41 to 43. So at 41 it says, according to a fourth aspect of the present invention, there's provided a method of displacing water from a trackbed in use during the passage of the vehicle along the track laid, as claimed in Claim 14. Now, Claim 14 actually is not exactly in these terms, but this picks up the point my Lord Justice Arnold has made, is that at 42 it says the method of displacing water from a trackbed in use may comprise the steps of, and then the first paragraph is essentially Claim 1, and then this second paragraph, following passage of the vehicle, the load on the liner may be such that liquid water impermeability is restored, thereby preventing return passage of the water through the filtration layer. This therefore provides a dewatering effect, enhancing the shear strength of subgrade. So again, we say that's entirely consistent with our interpretation of the patent and doesn't require any gloss to be included along the lines of an
When it says the load on the liner may be such that liquid water impermeability is restored, does that simply mean that I mean that can't be just a reference to the track and ballast, can it? I mean, it's presumably indicating that what if you is it saying that if you had a huge amount of water up top, then it would stop it becoming impermeable again?
Yes, I think all it's saying is that once the thing returns to its state of equilibrium,
Yeah.
the state without a train there, as a practical matter, the water cannot pass back down through it. Or indeed, it won't pass up through it either.
So that the normal state of affairs would just be the normal weight of rails, ballast, etc. on top of the liner.
Yes.
And the water the water that's been forced up in those circumstances won't go back down again.
No, and it will run off to the side. And the benefit of that is then each time a train has passed overhead, a little bit of water is forced out, it dries out the clay and solidifies the clay. So, as mineralogist says, Arnold, it says you turn a problem into an advantage. Moving on then to paragraph 54, and this is now referring to one of the specific embodiments. Again, this is essentially repeating much of what has been said. It really doesn't add anything to what has been said before, but it just re-emphasises the point that water forced from below cannot return back down. Again, nothing in 54 which requires some limitation of the kind the defendants, appellants wish to imply. Paragraph 56 is a paragraph which my learned friend puts a lot of weight on. Now, paragraph 56 is in fact the only paragraph where some figures are given for what the typical static loading on the filtration layer might be. And that starts at line 12. Typical static loading on the filtration layer due to the ballast and the track would be less than 10 kilonewtons per square metre and maybe approximately 2.9 for a typical track having a 300mm depth of ballast and a density of about 1,000 kilograms per cubic metre. And then it talks about what the dynamic load will be typically when a train goes overhead, and it gives a fairly wide range, 10 kilonewtons per square metre up to 100 kilonewtons per square metre. This is not, though, setting any limitation in the claim. It's merely providing some facts and figures. And one can see why that was done when one looks at what the next paragraph, 57, is doing. It's then describing, again in similar terms to those we saw previously, what the upper and lower support layers need to do. Picking it up at 40, such materials have a high resilience and provide protection for the filtration layer against puncture by the ballast. Typically they have a thickness in the range of 5 to 20 millimetres, but the thickness will depend on factors including the anticipated loading to be borne by the track bed during passage of train, as well as the desired depth, weight and nature of the material forming the ballast. So what 56 is doing is telling you you need to expect that a typical static loading will be this and a typical dynamic loading will be that. So 56 is simply a statement of fact. 57 explains why. So we say that the patent really has a very simple interpretation. Normally impermeable means precisely what the patent defines it as meaning. Normally impermeable in the absence of the load of a train or other vehicle. Once one's reached that interpretation, one is driven inexorably to the conclusion that on the fact, that is precisely what Hydrotex does. There was a lot of debate at trial as to whether it worked, whether water came upward through it. But one thing there's not a debate about is that one is not likely to see depths of water more than about 2 inches deep, otherwise one's in a flood condition. And that therefore, because Hydrotex was impermeable to water at a depth of about 50 millimetres, might be more, it was indeed normally impermeable. So, my Lord, I've dealt with those submissions pretty quickly, but those encapsulate our submissions on the part of the appeal dealing with infringement.
Well, that's very succinct, Mr. Hicks. Thank you very much.
I'm going to move on then to consider
Novelty. Going on to novelty now.
I'm going on to novelty now. Unless there's any questions you'd like to raise with me on those points, I'm going to move on to novelty. And again, we say the judge's conclusion on novelty was right for the reasons he gave in his judgment. There does not appear to be any dispute as to the law. The simple question is whether Hoare disclosed the invention. Now, I know you've looked at this before, but perhaps if I can spend a little time looking at Hoare itself, which is in tab 2 of the supplemental bundle. And could I ask you to turn to the penultimate page, just so one has in one's mind exactly what the reconstructions of Hoare are. So figure 2 on the penultimate page is showing here an upper layer 14, it's looking at a cross section, some discs 12, a lower layer 10, and the lower layer has holes or slits made in it. And the patents, Hoare patents, the Hoare application says the lower layer is of a water impermeable PVC material with holes in it. So what figure 2 is showing is what Hoare describes as a construction with a type A material as the lower layer. And then over the page, at figure 4, one's got a cross section of a road, and in the context of Hoare, the ballast of a railway track is called the sub-base, and that's shown by 24, and then Hoare is placed below the sub-base or ballast and above the subgrade. But below that, figure 3, what that is showing is, and this is described in paragraph 27 of Hoare, that in this figure, the lower layer is impermeable to liquid water and impermeable to water vapour, and it has no perforations in it. So figure 3 is showing a construction with a type C material. If I could ask you to go back to paragraph 6.
So do any of the figures show a type B?
No.
Right.
So paragraph, Hoare's a pretty sparse document. It assumes a lot from the reader. And there was a discussion about it, which was, I think everybody agreed, it is just a sparse document. But if one looks at paragraph 6 of Hoare, what Hoare is saying is that one has this upper sheet of material, the discs, and then at line 15 it says the lower flexible sheet material, so that was item 10 in both figures 2 and 3. The lower flexible sheet material can be what we call the type A, and we can see here we have a cascading or a sequence of degrees of permeability. So A is substantially water impermeable. In other words, it's a PVC sheet or some kind, but with perforations or slits there through.
That's figure 2.
Yeah. Yes, which open into the gaps. And there was discussion about that. And the holes are quite large. They're millimetres wide, and they will allow water, clay, and indeed small stones to go through them. So that's a very permeable product. B is the one we're interested in, that is water vapor permeable, but substantially impermeable to liquid water. So that's the next down. Water vapor can get through, as indeed it obviously could with A, but liquid water can't get through in B. And then C is completely impermeable.
C is figure 3.
Figure 3. Completely impermeable. So that's what one's got three options: completely impermeable, extremely permeable because it's got holes in it, and water vapor permeable but substantially liquid water impermeable. And paragraph 8 describes a slightly different structure, which is nothing to do with the lower layer, but slight variation on the way the upper layer is constructed. But again,
need to worry about that.
We don't need to worry about it now. Now, the only description of beyond this of what the type B material is in 17. But if I may just pause at that point, we say that 6 and 8 are not what one might say is a promising start to a novelty attack, because there's no statement in Hoare that one should make a product which is impermeable to water when not under the load of a train, but permeable when under the load of the train. There's simply no instruction to do that, as the judge pointed out. And there's no instruction in Hoare which tells the reader that the lower layer should also be made of something which allows liquid water to pass through it under certain circumstances, but not others, and that when it does that, that lower layer should filter out particles of clay. So that is not a promising start to a novelty attack. On its face, Hoare tells you nothing about the invention in question. So what the appellants have to say is that the inevitable result of following the instructions given in paragraph 17, the inevitable result is that one would make a product which falls within the scope of the claims. And the case law is quite clear on the point. It's not enough to show that a possible result, particularly a possible result which you can achieve when you know what the patent consists of, a possible result can be achieved. You have to show that it's the inevitable result.
But the case that's put against you, in effect, is one of accidental anticipation.
Accidental, indeed. It's a kind of accidental anticipation or inevitable result case. Although Hoare didn't know it, one is inevitably driven by paragraph 17 to make something which falls within the scope of the claims. And that involves a two-step process. First of all, deciding one's going to use the Gore type product, and secondly, alighting on example 10. And we say there is simply no justification for that approach, especially if one looks at what paragraph 17 actually says. So if I can now take you to that, in the case where the lower flexible sheet is a type B material, i.e. water vapor permeable but substantially impermeable to liquid water, such material might be, it doesn't say must be, it says it might be a composite sheet formed of a pair of outer water permeable textile layers with an intervening water vapor permeable layer. So that's what it says you need, is a water vapor permeable barrier. And then it doesn't say this is the only way you can make such a thing, but it gives you an example of how you might make such a thing, or at least how you might make the barrier layer. A barrier layer formed of an unsintered sheet of PTFE, which is expanded so as to produce a fine microstructure characterized by nodes interconnected by fibrils. So Hoare is not promising the reader anything more than you may be able to create a suitable barrier layer by using a microstructure characterized by nodes interconnected by fibrils. Doesn't promise that any particular example in Gore will be suitable. It does.
Well, is promise the right way of looking at it? I mean, the question is, what directions does it give you rather than what promise it makes?
Yes, it doesn't direct you to any particular. Logic, of course, right. It doesn't direct you to any particular example. It doesn't say that any particular example will be suitable. What it says, though, is that a product of that kind, namely a fine microstructure characterized by nodes interconnected by fibrils.
Well, if you sort of construct a hierarchy of examples, what you're looking for is something which is vapor permeable but substantially impermeable to liquid water. So it could be a composite sheet, that's a sort of top layer example. If that's the route you go down, well, it could be a barrier layer with unsintered sheets of PFTT. And if that's the way you want to go down, you could get one from Gore. And if you go to Gore, there are 10 choices.
Yes, but it doesn't actually. It says see, for example, Gore,
Yeah.
and that is in the context of a generic description of a product, a fine microstructure characterized by nodes interconnected by fibrils. It's not telling you that any particular example in Gore might be suitable. So what we say is the direction which is given, and I'll come to look at Gore in a moment, but what we say the direction given in the patent is that if you decide to make a barrier layer and you wish to use an unsintered sheet of PTFE expanded, if you want to know more about how to make that, see Gore. So it's telling you what you need to do is either source from somewhere or make for yourself something which is a fine microstructure characterized by nodes interconnected by fibrils, using what is described in Gore as the process. Now, what Fiberweb didn't attempt to show, they produced no evidence to this effect, for obvious reasons, that any product made according to what Gore describes would fall within the scope of the claims. They had no attempt to show that. And they couldn't show that. So it relies upon an interpretation of clause 17 of Gore, which is that for some reason you're told to select example 10. And we say that is exactly, many of the examples don't give details of permeability. We can look at them after the shorter journey. But the one thing one would not do, we say, if reading Gore, is select example 10, precisely because Gore explains that that is a product which not only has water vapor permeability, gas permeability, but also liquid permeability. So you're told in paragraph 17, don't choose that. And Fiberweb's case is based on the proposition that there must be somewhere within Gore an example, as opposed to a general description of how to make the product, which satisfies Mr. Hall's requirement. But there's no reason to suppose that there is.
And that's why the judge said that Hall teaches away from example 10.
Exactly. It points in precisely the opposite direction, because you're told it must be substantially impermeable to liquid water. So why choose an example which tells you that it isn't.